On January 15, 2009, Louise Brown, a 92-year-old woman, went to her local Safeway store to shop and to socialize with the store workers. As she returned from the store, she drove her powered wheelchair to the crosswalk at the intersection of North 7th East and East Pershing in Riverton, Wyoming. She backed her wheelchair against the edge of the curb, looked both ways for oncoming traffic, and after she had determined the way was clear, she began to cross the street in the designated crosswalk. Louise was halfway across the street in the crosswalk when an R&S well-serviced truck driver turned his company truck from North Pershing onto East Pershing, where he ran smack dab into her. Louise was struck in both her ankles with a portion of a pipe rack that was attached to the passenger side of the R&S well-serviced truck. Both of her ankles were broken. She required surgery to repair her left ankle. Even after surgery, her left ankle was deformed, and because of the risks she faced with a second surgery, her physicians decided there was a greater risk from the surgery than from living with the deformity. Today, the Insider Exclusive goes behind the headlines to show how Vance Countryman, Louise's lawyer, took on this oil services company and got justice for Louise. Hi, I'm Steve Murphy, and this is the Insider Exclusive, live from Lander, Wyoming, at the law firm of Vance Countryman. It is my great pleasure to introduce Vance Countryman. Welcome to the show, Vance.
Thank you.
I like your office here. It's really homesteading in Wyoming, isn't it?
It is. We've been here about a year, and it's a very nice facility for what we do.
You're almost what folks might believe to be a country lawyer, aren't you?
I'm about as country as it gets, having made it through law school.
What type of, tell us a little bit about why you went to law school. Why did you become a lawyer?
Well, I graduated from BYU originally, and I worked for two large corporations, and I just didn't fit. I thought you were there to make your employer money. I didn't understand that you were really there to make your supervisor look good, and I didn't fit. And I decided that I would go to school and get something that they couldn't take from me, and I decided to be a lawyer, and it fits me very well and has served me very well.
You're originally from, well, you lived in Lander for a while, didn't you?
I was born and raised in Fremont County.
Fremont County, and you lived in Hudson.
Well, I lived in Jeffrey City through about the 7th grade, 8th grade, and then when I started high school, my mother and father moved me into town, and I went to high school here in Lander.
When you first became a lawyer, what were the kind of cases that you initially handled?
Well, when I first started, I worked for the Fremont County Attorney's Office, and I was a deputy prosecuting attorney. So I did that for about 6 months, and literally one day I had to charge my groceries on a credit card because the county's paycheck wasn't enough to meet my needs. So I decided maybe there was something wrong with that process. And I then went to work for an attorney in Riverton.
What is your practice today comprised primarily of? What type of cases?
We focus primarily on litigation. I would say 80% of our cases are personal injury type cases. Now that doesn't just mean auto collisions, although we do those. We do civil rights cases. We're involved right now in a trademark infringement case. So if it's related to the courtroom, that's where we put our efforts.
These are little guy cases. You are representing little people against corporate America, insurance companies, that sort of thing, right?
Absolutely. We represent individuals. Even when it comes to representing businesses, it's still mom and pop type businesses who are confronting people that are trying to take advantage or have taken advantage.
Yeah, a lot of people don't realize until they get in an unfortunate situation that you really need a good trial lawyer to make it today, simply because corporate America has well-paid law firms that kind of like squash you out, don't they?
honestly, the attitude in this country today does not favor the individual. Mm-hmm. For some reason, we've bought into the idea that corporate America is the mechanism that provides us our lifestyle, and this simply isn't true. The fact is, in my opinion, corporate America is no different than the feudal system that existed in England when we left England. Mm-hmm. And we're just now being confronted with the hardships of that system.
Do you think people feel it's almost impossible to win against corporate America?
I think they do. And to be honest with you, it's very difficult. People ask me, I go to Las Vegas to different CLEs, that kind of thing, and they ask me if I gamble, and I tell them I never gamble. I never spend a dime. Yeah. Because every single day when I invest in a case, yeah, that's all the gambling, yeah, whatever you want to call it.
Yeah, and I think it's important for our audience to really understand that you as a plaintiff lawyer, when you say invest in a case, you don't take any money from anybody when you take on a case, and you only earn any money if you win it.
Oh, absolutely.
And oftentimes when you win it, it gets appealed.
We literally, every dime that goes into these cases is our money. Mm-hmm. And if we don't win, if mm-hmm. we don't recover, generally that money's gone because clients just simply don't have the money to litigate these
sure.
cases.
We're going to talk about a little guy case today. This happens to be a 92-year-old woman, Louise Brown, versus R&S Well Services Oil Company. Talk to us about the facts on this case.
Louise Brown is just the most wonderful woman. She's 92 years old. She still, at the time, she lived on her own. She had her own apartment.
This was in Riverton?
In Riverton, Wyoming. Okay. And on this particular day, she had gone to the Safeway. She had a few odds and ends she wanted to pick up, but I think the truth was she wanted to see some people, socialize. She knows the store manager over there on a first-name basis. She knows the clerks. She had got her a couple items, and she was coming back. And
she traveled around on a motorized wheelchair, didn't she?
She did. She had a little scooter that was self-propelled, and she was returning from the Safeway store. Mm-hmm. She had literally gone to the designated crosswalk, looked both directions, started across the crosswalk. Halfway across the street, a one-ton truck owned by R&S Well Service turned the corner and struck her with a pipe rack that was hanging off the right-hand side of the truck, and it broke both of her ankles.
Now, they admitted the liability here. In other words, they admitted they did this, that she was in the crosswalk, rightfully so. That was first and foremost, wasn't it?
Well, the irony is they did acknowledge that she was in the crosswalk, and they did acknowledge that she had the right-of-way, but they denied liability.
Right.
And they denied liability throughout the entire proceeding.
And how does a sane person come to that conclusion?
Well, you have to understand the mindset of defense lawyers.
Yeah.
Sometimes they will admit liability, but they don't do that because they really believe they're liable. They do that because it allows them to exclude evidence of the wrongdoing of their client. And so what they're concerned about is if their conduct is so outrageous, it might inflame the jury. But that's the only time they ever admit liability, because their position usually is you have to prove every aspect of it, no matter how egregious their client's conduct was.
And what was their position regarding Louise Brown?
Louise Brown, from their perspective, they wanted to know about her prescription to her glasses. They wanted to know when she had had her hearing checked last. They wanted to know where she was looking at the time. Irrespective, their position was irrespective of the fact she was in the crosswalk.
Despite the fact that she had the right of way, she was in a crosswalk crossing the street, that was almost irrelevant.
They hired an expert, and he's amazingly expensive. I mean, he charges as much as a doctor on an hourly basis. And his opinion was that the truck was large, it was red, Louise Brown should have seen the truck, and in large part, this collision could have been avoided had she stopped her wheelchair.
Had better eyesight, better hearing. It was her fault, in other words.
That was their position.
So now knowing all this, what was your strategy to win this case? Because you did win this case.
Well, we took them head on, and I'll be honest with you. I think trials are like fistfights.
Yeah.
And we got right in the middle of them, and we confronted them with what we understood the law was with regard to access to crosswalks.
Right.
We confronted them in court and argued successfully, I think, that the common law was abrogated by a statute which gave her the right-of-way in a designated crosswalk.
Despite the fact that the truck was red, despite the fact that her eyesight might not be 20/20, right? In
Absolutely.
other words, her expert became irrelevant, didn't he?
Well, from our perspective, it happened to be Louise Brown who was impaired in that her age would not allow her to walk quickly.
Yeah. And she was 92.
She's 92, but she could have been blind. She could have been impaired in hearing. Those crosswalks are intended to make it safe for us all.
It's sacrosanct.
Exactly. In my mind, it is a free zone for pedestrians to cross the street.
That's why they have them.
That's their sole function.
Yeah. Now you took this. Did you go to trial on this?
We didn't. We settled the case.
Did they finally have the sense to see that they would lose at the court level, trial level?
I think that they probably believed they were going to lose at every juncture.
Yeah.
I think that their perspective was they wanted to try and reduce their losses.
Yeah. And this is an interesting point that you bring up. When you took the case on and you did all of this homework, you're preparing, you probably took depositions, correct?
We did, yeah.
Now, you're ready to go to trial. When did they settle? How soon before you're ready to go to trial?
We were actually a month and a half out from trial, but we were at the end of the discovery process.
Yeah. And they're aware of everything that you have gathered now, right?
They are. We are obligated to disclose everything that we have that supports our case initially, right at the beginning.
Right.
And then, of course, we're obligated to supplement that as the case proceeds.
So when does the light bulb go on where they say, you know, it might be better for us to settle?
Having never been a defense lawyer, I don't quite know how their psyche works, but I do know that at some juncture they are recognizing that a jury could get really upset at a case like this. And
are you in communication with the defense lawyers telling them this?
No, I've learned, at least from my perspective, telling people who know it all something is not really useful.
Yeah.
I tend to try and just send them information, whether it be photographs or medical records, but I try to avoid conversations. I just simply, oh, here's another photograph. Yeah. Here's some x-rays.
Right.
Here's a diagram.
So you get a phone call from them.
Yes.
And they say, we'd like to settle.
Yes.
Okay. And since the case is, you know, out in the open, in the settlement, we can talk about that in a minute. What did they initially come in at, dollar-wise?
To be honest with you, I don't remember exactly. It was somewhere over $100,000 or in that $100,000.
Where do they come up with that number?
You know, adjusters, when the case starts right from the beginning, they have, I can't remember what the phrase is called now, but they have limits that they set for that claim.
Yeah.
And that goes in, and until, I mean, that can be the biggest problem, is demonstrating that the adjuster undervalued the case to begin with.
And then obviously you come back and you say, we want this number, right?
Yes.
What was the case eventually settled for?
We settled the case for $300,000.
Putting the money aside, and congratulations on that, was there an apology or anything?
No.
Was there admission of liability?
No.
No admission of liability. Here,
in fact, there was, they maintained a denial of liability.
And what's the purpose of that, by the way? I mean, they're paying you money. Anybody with, you know, common sense is going to say, well, you don't pay people money unless you were at fault. What's the purpose of maintaining no liability for the record?
I have never understood why they care about that, because as a practical matter, the case is done. There's nothing more that can be done.
Right.
So whether they admit liability or they don't admit liability makes no difference.
Yeah.
But it is a standard clause from every defense firm I have ever seen that the liability is in dispute and that this is a settlement of a disputed claim without admission of liability.
So let's say you had another client come to you, exact same circumstances. You know, a truck runs through. Can you use this case as a precedent even though they haven't admitted any liability?
The answer is no. The law itself would be applicable, but short of that...
The law meaning she has the right of way in the crosswalk.
Exactly.
Okay, but you can't bring to a jury, by the way, R&S Well Services settled a similar case for $300,000, you know, 2 years ago or a year ago, whatever. You can't say that. You can't introduce that.
The court would never let that in because it's not relevant what happened in another case.
Yeah. It seems to me it's pretty relevant.
It literally, I cannot imagine a circumstance where a judge would allow a jury to understand what another case settled for.
Yeah.
And I can tell you the defense would never agree to it. That would be the first thing on appeal.
If they had admitted liability, could you introduce it?
I think the only way it could be admissible if the defendant happened to be R&S Well Service again and the same kind of incident happened without a change or corrective policy.
Right.
That would be the only way I can see.
So it would show a continuing pattern of misconduct.
Right. If you would then be seeking exemplary damages because they are acting in a willful and reckless manner towards other people.
How's Louise Brown today?
Louise Brown's left leg healed with a slight deformity. She would have, had she been 50, they would have operated again and then reset that leg to correct it. And the way her doctor described it was that her foot strikes the ground before her mind expects it to happen, and therefore it causes her difficulties walking.
Yeah.
But her right leg healed relatively correctly. And she now, though, she used to be able to move around without a walker. She could rely on furniture, other things. Yeah. She can't do that anymore. And she'll never be able to live independently again.
Mm-hmm. You brought up before the show that trial lawyers are a dying breed. Why is that?
We're being legislated out of existence.
And how is that happening?
Well, in my humble opinion, corporate America controls Washington and in large part even controls our state legislatures. And for some reason, America seems to believe that it's more important to take care of corporate entities than it is individuals. And so, although we survived caps, I think about 4 years ago, caps on damages in med-mal cases.
Right.
That did not pass. Virtually every state around us has caps.
Yes.
And I think it's a moving trend. I think that people who have not been hurt do not understand the loss that an individual suffers.
Yeah. You know, you bring up a good point about caps. Caps on non-economic damages, pain and suffering. What is it worth, right?
Yes.
In a lot of states, I think in 30 states now, is it 30 states?
I don't know.
Something like that. They have caps on pain and suffering, okay? How do you convey to a jury, you don't have it in this state, how do you convey to a jury, how do you put a dollar sign on pain and suffering?
To be honest with you, I try not to do that.
Yeah.
I try to leave that to a jury to decide what they contend it is. The biggest difficulty with caps is that it treats our elderly, it treats our women, and it treats our children unfairly. You know, if you're a man and you work in the oil patch and you're making $60,000, $70,000 a year, it's relatively easy to show the losses that a man has suffered. The irony is
the economic losses.
The economic losses. Yeah. His wife, who's at home, who lives in that same lifestyle, supports that same lifestyle. They're both working the oil patch. It's just that she does her work at home.
Yes.
Taking care of the kids. He's gone 7 days at a time, and she has to take care of the kids during that time alone. She has to do all the shopping, all the hustling kids around. But for some reason, because she doesn't walk out on that oil rig and doesn't get that paycheck, for some reason, what she does in the household isn't worth as much as what he does, even though it takes both of them to make that lifestyle work.
I'll tell you, every housewife in America would disagree with that statement, wouldn't they?
They would.
You know, because they're very much part of that unit, that working unit.
It is impossible, in my mind,
Yeah.
to take care of a family without both parties actively pursuing their individual goals.
There are some myths that a lot of Americans believe, primarily because the U.S. Chamber of Commerce, corporate America, promotes them. One of them is, when we're talking about medical malpractice cases, that the U.S. Chamber of Commerce says the reason we have high costs in healthcare is due to those trial lawyers that are getting these huge verdicts in medical malpractice cases. True or false?
Well, it's absolutely false.
Why?
Several reasons. First of all, taking a doctor to trial is almost like taking God to trial.
Mm-hmm.
They are sacrosanct in their position in our society. And in fairness, maybe they ought to be. I mean, they literally hold our lives many times in their hands.
Mm-hmm.
And so for a juror to hold them responsible for an error is very difficult. That's the first issue. The second issue is that, there are statistical studies of the expenses associated with healthcare costs, and malpractice cases amount to less than 2% of that.
Right.
It is a travesty to try and defend the pharmaceutical industries, the health insurance the health insurance industries, their profits by laying that off on trial lawyers. The truth is, trial lawyers don't do anything more than allow a juror to see the truth.
Right.
Then the jurors decide whether or not they believe the standard which should have been provided was violated.
A lot of people believe, and I believe this is a myth, I know it's a myth, that trial lawyers are trying to put businesses out of business.
Oh, absolutely, that is not true. The fact is, I think it was Justice Cardozo. I might not have that right. But his point was businesses should bear all of their economic costs. And one of those costs have to do with the injuries their product causes.
Yes.
And what people don't seem to understand is that if the corporation doesn't bear that cost, society will. We don't put people out on the street because they're injured. What happens is the taxpayers end up being the underwriter for those defective products.
Right.
They pay it in Medicare, they pay it in Medicaid, they pay it in Title 19, they pay it in workers' comp benefits. All those socially funded systems pick up the costs where somebody's negligence or a product that was defective caused an injury.
When you are approached, when you take on a case, what is your philosophy regarding settling the case versus taking it to trial?
Well, first, the case belongs to the client, and they get to make the decision. It's my job to advise them of the pros and cons of taking the settlement. And we have to be mindful of the weaknesses of our cases as well. Obviously, every case has a weakness, and we need to understand or try to understand the repercussion of that weakness. Mm-hmm. And when we sit down and meet with them, I mean, sometimes it's just fiscally, we can't settle the case for that. What they're offering is simply not going to meet the needs of our clients. So we don't even have to make that decision because the defense has made it for us.
But you're prepared at all times when you take on a case to bring it to trial.
We don't take cases that we're not prepared to take to trial. We never take a case with the idea of settlement. And from the onset, our objective is to gather the evidence and get the information we think we need to try the case.
Because you've had a successful career as a lawyer, when you take on a case, the other side does their investigation of you to see if who you are and how you handle the case, right?
I'm sure that every lawyer has a reputation, and they make a few phone calls. I do the same thing. I size up the defense and find out who they are and what kind of things they do, and do they have a history of dirty tricks and
right,
that kind of thing.
With lawyers like yourself that are successful, that have good reputations, the little guy still has a chance out there to win some sort of justice, don't they?
The truth is, we're the only chance they have. Mm-hmm. There's no governmental agency that's going to help them. Even if there were some kind of criminal charge that's potentially there,
yeah,
that criminal system will not bring relief to the victim. Lots of times, many times, criminal convictions where there's been some kind of a physical injury, whether it's a sexual assault or a homicide, it's a hollow victory, because that family still has to go on. That loved one that now can't work or isn't available or now can't do what they did before,
yeah,
that money is still gone. And even if they qualify for some type of disability,
right,
that still pays substantially less than what they were earning before.
Even though you're in Lander, you handle cases all over Wyoming, don't you?
All over Wyoming, and we are now venturing into an interstate practice. We have a variety of firms that we associate with, both in-state and out-of-state.
Well, I'm very glad you were able to be on the show today. We learned a lot of valuable information, and we now know that the little guy still has a chance.
Let's hope he does, and let's hope that our society is as concerned about the little guy as they are about corporate America.
Thank you for being on the program.
Thank you.
Thanks for watching. You can get more information about our guest and the issues at InsiderExclusive.com.